Good morning. This morning I'm out here on Lido Key Beach. It's a gorgeous morning. It's a little warm inland, but out here it's quite nice with the sea breeze. So I thought this is a really beautiful location for kind of a difficult topic. And this topic is, if I don't decide who gets my children, a judge will decide. So in Florida, there's two ways to designate who you would want to be guardian for your children. You can do it in your will, and that's effective most times. But what happens if a parent's incapacitated? The child still needs a guardian, and a will doesn't go into effect until the testator dies. So what's a court to rely on in that case? Knock wood, I've never actually had to try that out, but again, technically the will's not effective. However, there's a second way to designate a guardian for your child that is effective from the moment it's signed. It's called a designation of pre-need guardian. And I always recommend using these in conjunction with a will. That way you can be fully certain that your choice will be taken into account. Now, coming back to the original topic, a judge gets to decide who gets your children. Well, that's always true. Even if you have designated in your will and designated with your pre-need guardian, because the courts always have the safety of the child in mind. And so if your designation turns out to be inappropriate for some reason, they can still name someone else. So the answer to this one is true. A judge will always have a say and the final say in who gets your children. However, you get to designate your preference, and unless there's a reason not to, judges will usually follow that. So thank you very much, and if you enjoyed this video and the views that went with it, please like and subscribe.